What's up, y'all? You're watching Union Minded, and I'm your host, Eric, joined by my coworker, Ross, today. And today we're going to be discussing grievances versus charges and how they apply. The reason this video is even being made is because not too long ago I was having a conversation with someone who is also an electrician, and they remarked how there was a situation on a job where someone was being abusive to them verbally, and the person didn't know how he was supposed to respond with that. And, I kind of gave him some advice, and he didn't know the process. He didn't have any idea of what the process would be to address a complaint, in essence, of those types of things. So that's kind of what gave me the idea to do this video. I feel like there's a lot of IBEW members who may not realize that they can protect themselves on a job site against abuse from other coworkers, abuse from the contractor, abuse from a foreman, or from mistreatment or bad conditions. There's like such a strength in unions, and it's a strength that doesn't get wielded many times. And I think ignorance is a strong contributing factor to why it doesn't get utilized. But I always say a local union is only as strong as its membership. You have to demand more. We pay a high amount in dues and everything else in order to have a very nice, comfortable living. And we are called to always reach for a higher standard of living. And so with that in mind, we should police our own so that we can protect what we've gained and negotiated for and fight for more. That all being said, please hit the like button, the subscribe button, the notification bell, and don't forget to share. Let's grow the channel, yada, yada, yada. Y'all already know. We gotta grow the channel so that we can increase the sphere of influence. Let's hop right into it. If you are an IBEW member, you're going to want to grab your Constitution. If you are an IBEW Local Union 26 member, you're going to want to grab your agreement, because we're going to be discussing both of them. All right, Ross.
Yes, sir.
These are our documents. Now, you're a part of Local 70, so what's in this book is not necessarily going to apply to you. But this book, the Constitution, applies to you because you are an IBEW member. All of us have to abide by what's in this book. It's very important. This is a legal it's a legal contract for all of us. The Constitution. All right. So what you're going to find in the Constitution is you're going to find, your Declaration of the International Brotherhood of Electrical Workers. Tells you what the purpose of the IBEW is. Tells you that, our cause is the cause of human justice, human rights, and human security, and blah, blah, blah. You're going to find what the order of business for all local unions is. So this is how union meetings are supposed to be run. It's a guideline for any local union to run their meetings. This is your guideline. This is how you do it.
In that certain order?
Yeah, it's actually in order. So it'll tell you, step one, you do an opening. For us at Local 26, we do the Pledge of Allegiance and a moment of silence for those who have lost their lives. But then you got the roll call of the officers. You got the communications of the bills, reports from the executive board and officers. Then you got, if there's new members, there's propositions for membership. And it goes on down the line, all the way down to unfinished business, new business, good of the union, and whatnot. And then then you end it and get out of there. But that's the order of the business meeting for the local union and the members to come together every month and talk about the business of the local and how it's doing. Okay. Next, you're going to find the objects of the IBEW. The objects of the International Brotherhood of Electrical Workers are many, and they're all very cool. I mean, I could just grab one random one, and you'll see to secure employment. So one of the things that the IBEW has as an objective is to secure more employment, which makes sense because we're a labor union, trade union, but it makes sense that they would want to secure more employment. So they set that down as a bullet point on their objectives. But what they also have in here is to reduce the hours of daily labor, to secure adequate pay for our work, to seek a higher and higher standard of living. All these things are important. So it's a lot of bullets. It's not just one thing. You can't pick and choose. All of them are important, and the IBW strives to accomplish all of them. Does that make sense so far?
Yes, sir.
Stop me with any questions you may have, because I know that this book is it's a big. I mean, it's massive. It's over 100 pages of contract legalese. All right, so then you got the table of contents. This is going to break down all the different sections of the book, just like any other book. It'll tell you about the international convention. It'll tell you about international officers, the president, international president. I'm sorry. It'll tell you about the international secretary treasurer, the international vice presidents. It'll tell you about the different districts. It'll tell you about the executive council. It'll talk about all the different funds that we have: your pension fund, your legal defense fund. It'll tell you about local union charters. So I'm a part of local union 20. Well, I'm a member of local union 26. But you got locals all over the country, and each one is a different designation, but they all have to abide by the Constitution. And that's what's awesome about this thing. And that's why we can go across the country and work at different states of different locals that are all a part of the same organization operating in the same fashion. So rules for local, it tells you local union charters, so how you set that up. Rules for local unions. So this will tell you even how that local union is supposed to be run so that it stays within the purview of the Constitution, so that they don't go outside of the Constitution. So if you know your Constitution, you'll be able to spot when a local union is doing the wrong thing and may be able to raise questions about it. Let's see, what else? Duties of local union officers. So this will tell you the office and what the duties of the office holder of that office is. And it breaks down each position in the local union. It talks about what it takes to become a member, because it has qualifications of members, admissions of members. It talks about when you're in arrears, about you haven't paid your dues and you're in arrears. It tells you what the consequences are for that. It all these rules, but the one section that I kind of want to hone in on has to do with, for us, policing ourselves, which would be misconduct, offenses, and penalties. And for that, they tell us to turn to page 77. So we go to 77. I got somewhere around here. All right, page 77. This is Article 25. We're talking about misconduct, offenses, and penalties. All right. Any member. That's an important term because it encompasses everybody. Any member may be penalized for committing any one or more of the following offenses: violation of any provision of this Constitution and the rules herein, or the bylaws, working agreements, or rules of a local union. So what does that tell me as a member? It tells me that if I violate anything that's in here, or if I violate anything that's in here, that I personally can incur a penalty of some sort, right? Because it's a misconduct, offenses, and penalty.
Right.
So any member can be penalized. That means if I violate any of these two agreements, I can be penalized. But I don't know what that penalization is going to be.
Well, jail time?
Damn, that'd be messed up. Imagine that. Jail time? Oh, God, I hope not. But I'm saying, you can be penalized for, because, some people, they join a union and they don't understand that.
Well, monetary too?
We're going to find out because we're going to delve into it. But what I mean to say is, a lot of folks get into the union and they don't realize that you have to behave, you have to abide by these things, or there can be a repercussion for not doing it. Like there's people that, they'll shit it in and they're installing stuff that's unsafe and they're making the union look bad. And there's all these bad characteristics and character traits. And you feel helpless because you're like, what am I supposed to do? You know what I mean? It's another brother over there, and yeah, he's doing whatever, but what am I supposed to do? Well, no, we have a standard to uphold. You know what I'm saying? We are union electricians. This is not, we're supposed to be better than the average Joe. So we got to hold each other to account to make sure that stays the way it's supposed to be, or the way it is. So for violating any of this, you can be penalized. It also says that having knowledge of the violation of any provision of the Constitution or the bylaws or rules of a local union, yet failing to file charges against the offender or to notify the proper officers of the local union is also a means for you to get penalized. Don't know what the penalty is going to be because I don't know what happens. We haven't gotten there yet. We're just reading. But you can be penalized. And there's a whole list of things. Go ahead. What you
say? So basically, if I see something going on, if I don't tell nobody, maybe the next guy can see. He can tell too, right? Basically.
Yeah. So let's say you see me do something that's wrong, and there's a third witness, right? And they come to you and they say, "Hey, man, you just saw that. That was wrong." And you act like you ain't see nothing. That dude can then go and say he witnessed it and didn't say nothing, and he did it. And that'll be both of us tagged up in the same drama. Make sense?
Yeah, yes, sir.
If it doesn't, please ask, and we'll try to clarify it. Now, I'm not an authority on this. I'm just talking to you about it as someone who's reading it and giving you my understanding. I'm by no means an authority on this stuff.
Sure?
No means. Not at all. I'm just reading, and I like to read, so I'm reading. Another one is obtaining membership through fraudulent means, right? Engaging in activities designed to bring about a withdrawal or secession from the IBEW. That's another one. Engaging in any act or acts that are contrary to the member's responsibilities towards the IBEW. Again, we talk about objects. We talk about the stated goals of the IBEW. If you're behaving in a manner that's contrary to that, you can be brought up on charges because it says it right here. Engaging in any act or acts that are contrary to the member's responsibility towards the IBEW or any of its local unions as an institution, or which interfere with the performance by the IBEW. So, I mean, working for on behalf of an employer who is in opposition to the IBEW. That's another penalizable offense. You see, these are all things that people can do wrong. Wronging another member is another penalizable offense. Entering or being present at any meeting drunk is a problem. Disturbing the peace at a meeting is a problem. These are all things that you can get in trouble for.
Could you be suspended too?
Well, let's go. All right. So there's a bunch of offenses, right? So let's go forward because we talked about the offenses, and let's see what happens. It says, any member convicted of any one or more of the above named offenses may be assessed, which means fined, right? Or suspended, so you can't work for whatever amount of time, or both, or expelled altogether.
Completely
kicked out of the IBEW. So if it's bad enough, you can get kicked out of the IBEW. This is not a game. Too many times we treat it like a game, but it's not. I mean, this is our...
That'd be like a lifetime expelled.
Yeah, expelled means you're done. Bye. Good night, Irene. It's over with. It's over, Johnny.
Hasta luego.
Hey, she's not for you, man. She's gone.
Yeah.
But anyway, so yeah, I mean, that's pretty serious. And then you have, it says here, if an officer or a representative of a local union is convicted of any one or more of the above named offenses, the same can happen to them.
So nobody's better. So nobody's better.
No. We are all IBEW members. Some of us work in the field. Some of us work in the local union offices. Some of us work at the international, but they're still IBEW members. If a member or officer or representative of a local union is assessed and fails to pay the assessment, they can be sued. A lawsuit may be filed to collect the unpaid assessments. So this is pretty serious stuff. So now we got charges and trials. Charges and trials. All charges except against officers and representatives of the local union shall be heard and tried by the local union executive board. So if you're not an officer in the local, that means that if charges are brought against you, the executive board of your local union is going to do the trial. They're going to sit there and get the information and everything else and render a decision. If it's an officer that is being charged, they'll have to go. Let me see where it says it. A majority vote. Okay, so you go in front of the executive board, which shall act as the trial board in accordance with this article. A majority vote of the board. Let me just finish real quick. A majority vote of the board shall be sufficient for decision and sentence. What is it?
But can I have like a representative with me too at that executive board? Let's say like a shop steward.
It's like a trial, so yeah, you'd be able to bring witnesses for your side. I'm sure the charging people will have witnesses for their side, and it's going to be like a trial. And the executive board is the judge, jury, and executioner. So they're going to listen to everything and decide fairly what should happen.
Could it happen the same day, the over with, or could it be a holdover a couple of days, or?
Well, there's time limits for different things, and so let's see what happens. So I'm on this section. All charges against a member or members must be presented in writing. Okay, so if you wanted to file charges against me because I did something wrong to you, you would have to present it in writing. It would have to be signed by you as the person making the charges, and specify the section or sections of this Constitution or this agreement. And also, it must state the acts that are considered in violation, including the relevant dates and places. So you can't just levy charges willy-nilly. You got to have some proof. You got to have dates, times, witnesses if there's witnesses, and you have to put your name to those charges. So you can't do it anonymously. You can't just be like, hey, Rand, I'm just going to let you know that this dude over here is screwing up. And, yeah, I just don't want my name attached because I don't want... No, you have to face your accuser when you're charged, right? Mm-hmm. Same deal. You got to face your accuser. So make sure you got your ducks in a row if you do decide to file charges. So that way you don't end up with egg on your face accusing someone of some wrongdoing and they ain't do nothing wrong. Make sure they doing something wrong if you're going to accuse them of wrongdoing. You know what I'm saying? But, again, it goes back to... we have to police ourselves, because if we don't, we allow members who undercut the other members and undercut the contract and do all the little things that they're not supposed to do. It erodes the strength of the union. And if you don't hold them accountable, they'll continue to do it. And that type of behavior will spread, because those types of folks don't got the right idea about the union anyway. They either was organized in and didn't get taught about what the union is about and how we're supposed to function, or they came up through the ranks and a contractor got a hold of them young and exploited the crap out of them, and now they think they're rock stars and they don't understand. They just worker peasants like the rest of us. Okay, so you already know that you have to have it in writing and all that stuff. So who would you bring the charges to if you want to file charges? Charges against members must be submitted to the recording secretary of the local union, in whose jurisdiction the alleged act or acts took place. And it has to be within 60 days.
2 months. Huh?
Within 60 days of the time the charging party first became aware or reasonably should have been aware of the alleged act or acts. So you got 2 months. You see something and your conscience is messing with you because you don't want to say nothing because that's a brother, and you got 2 months to figure it out. The charges shall be read out but not discussed at the next regular meeting. And then there's a trial between the two parties, and the executive board does their thing. And then at the following meeting, the decision, I don't even think the decision gets told, but we'll get to that part too. All right, so the charges shall be read out but not discussed at the local union meeting following the filing of charges. The recording secretary shall immediately send a copy of such charges to the accused member at his last known address. So the recording secretary is responsible for getting your charges, a copy of that sent to the guy or the gal who you're charging, the one who did the wrong. You know what I'm saying?
Yes, sir.
And that written notice will also give them the time and place where they need to appear before the trial board. Trial board shall proceed with the case no later than 45 days from the date the charges were read at the local union meeting or executive board meeting. The board shall grant a reasonable delay to the accused when it feels the facts or circumstance warrant such a delay. So that makes sense. So basically, you got 60 days to file the charges. Once you file the charges, those charges need to be read at the union meeting. When those charges are read at the union meeting, they now have 45 days to set the trial and take care of it. 45 days, that's the window. All right?
45 days.
Yeah, the trial board shall proceed with the case no later than 45 days. So they can do it immediately. Like after the meeting, the next week they can call it. But they have 45 days to get it done. When the trial board has reached a decision, it shall report its findings and sentence, if any, to the next regular meeting. So they do have to tell the local union members what happened. So they give you the charges on March. Whenever it's done, they come back and they say, hey, this is what happened regarding those charges. That's kind of cool that they'll let you know.
So anybody...
That way the rest of the people understand that that's a charge that's serious and you got to behave accordingly.
Yeah.
Such report or action of the board shall not be discussed or acted upon by the local union. The action of the trial board shall be considered the action of the local union. Okay, that makes sense. All that makes sense. Let me see. There's something else that has to do with some dates or some time. Let me see. Should report the findings, if any, to the next regular meeting. Such report or action shall not be discussed. The action of the trial board shall be considered the action of the local union, and the report of the board shall conclude the case or cases except for the accused having the right to appeal. So if you're charged and you're found guilty, you do have a right to appeal.
Now, how long does it take for the appeal process?
We're gonna find out. Except for the accused having the right to appeal to the IVP, that's the international vice president of that district. Then to the international president, then to the International Executive Council, and then to the International Convention. So you can appeal it all the way to the International Convention. However, the board may reopen and reconsider any case or cases when it feels the facts or circumstances justify doing so, anytime within 30 days from the date the decision was rendered. The board shall reopen any case or cases when directed to do so by the IVP or the IP. So if the accused willfully fails to stand trial or attempts to evade trial, the trial board will proceed as if he's there. For appeals, any member penalized or otherwise disciplined by the local union trial board may appeal to the IVP anytime within 45 days after the date of the action of the trial board. A charging party may not appeal a local union trial board decision. So if I laid charges against you and they found you not guilty of what I said you did, and I'm mad because I know you did it, that's the end of my rope. That's all I got. I can't go above them and say, well, they're looking out for their friend. I can't do that.
Huh. So you can't appeal that?
No, not as a charging person, but as someone who gets charged, you can appeal. A copy of any appeal must be filed with the local union.
Yeah, it's all recorded then.
Oh yeah, everything has to be recorded. And then there's also, if you're assessed a penalty, but you still want to appeal, you still got to pay that penalty until your appeal overturns the decision. And then at that point, they can give you your money back.
Oh, so you get your
But
money.
you got to pay, because if you don't pay, you're not going to be eligible to get the money that back. And you might even mess around and not even be able to appeal because you're not paying.
So how much is it like a base amount of money per charge, or
it's whatever the board. It's whatever the board decides is a fee for you for what you did. It says no appeal for revocation of an assessment shall be recognized unless the member has first paid the assessment, which he can do under protest. So you got to let them know I'm protesting this, but I'm gonna pay it. When the assessment exceeds $50, payments of not less than $40 in monthly installments shall be made until the assessment is paid or until a final decision on the appeal is made, whichever one comes first. The first monthly installment must be made within 15 days from the date of the decision.
Yeah, 2 weeks.
2 weeks from when the trial is over, you got to make your first payment.
Huh.
A member who's been assessed, who is appealing the assessment and making the required monthly payments in accordance with this section, retains his good standing status until the appeal process in this article has been exhausted. When a decision has been rendered by the IVP, it shall become effective immediately. No appeals from decisions from the IVP or the IP or from the IEC shall be recognized unless the party or parties appealing have complied with the decision from which they have appealed. However, this section may be waived by the party making the decision if good and sufficient reasons are furnished, and he is required to do so.
Okay.
So if you don't start paying your bills, you can't get that appeal anyway. So how you like them apples?
Yeah, but basically, I can appeal it. Then I pay my bill. They're gonna appeal it the same day, or I have to wait after that.
No, you gotta pay. You gotta pay within 15 days. As long as you're paying, you're able to appeal. You can even make the first payment under protest and say, I'm gonna appeal this. Put that in writing. I am gonna appeal this. This payment is being made in protest, just to let them know, hey, I'm paying this, but I'm not guilty.
Right.
I'm fighting this. You know what I'm saying?
On the same day, basically.
Yeah, I mean, however it works, it's probably on the same day. But so that kind of gives you an idea of how we police ourselves member to member, right?
Mm-hmm.
I also talked about holding contractors accountable for what they agreed to, because what we got to remember is that a collective bargaining agreement is an agreement between the workers and the contractors. So they're responsible for their end of the bargain, as much so as we are responsible for our end of the bargain. And remember, by what we read in the Constitution, anyone who violates this joker, whether it's a member or the contractor, can be either brought up on charges or have a grievance filed. Now let's talk about grievances. I'm looking at my local union contract, and you got your table of contents just like on your Constitution. It gives you basically a quick reference guide for what you're looking for. And I see right here under section 1.06, grievances, page 4. So let's go look at page 4 and see what it says about grievances. So page 4, it says right here, Labor Management Committee. All right. It says right here, grievances under section 1.06. All grievances or questions in dispute shall be adjusted by the duly authorized representative of each of the parties to this agreement. In the event that these two are unable to adjust any matter within 48 hours, they shall refer the same to the Labor Management Committee. Shall be duly authorized. Shall be adjusted by duly authorized representative of each of the parties to this agreement. That means that the contractors can have a representative represent them, and then the local union can have a representative represent the member filing the grievance. That could be a business agent, a steward, anyone who is in official capacity. And they can meet and try to mitigate whatever the conflict is. Now, what would the conflict be? A violation of this agreement will be something you can file a grievance for. And then there was another thing that I saw here with grievances. It says grievance notification. There's rules for that too. So you got grievances. We know what that is. That's between the union member and the contractor. That's what a grievance is. And then you have grievance notification. Let's see what they intend to tell us there. That's page 5. Okay, over here I see grievance notification. It says grievances or questions in dispute shall be filed with the duly authorized representative within 15 days of the event or within 15 days of the grievant becoming aware of the event. Any grievance not brought to the attention of the responsible opposite party to this agreement in writing within 21 days of the event or grievant becoming aware of the event shall be deemed no longer to exist. That means you got, as a union member, if you want to complain against your contractor because they did something that violated the agreement, you have 15 days to file that grievance. And then your local has another 6 days to notify the contractor that there's a grievance and to work out a solution. Or actually, no, to let them know there's a grievance. If they wait till after 21 days, the grievance doesn't exist.
I have a question for you.
What's up?
On this agreement here for grievances, right?
Mm-hmm.
All right, say it's not the company that I'm working for, the employee I'm working for. Say it's another company. Say like the GC. Can I still file grievances against the GC? Or it has to be your only employer? No,
I don't think you can file a grievance against the GC because you don't have a contract with the GC.
Well, you having issues with them?
Yeah, you do. You would bring it to your company and have them deal with the GC, and then if that's not to your satisfaction, then you have a grievance against your contractor for not doing the right thing.
Okay.
But this is an agreement between electricians and contractors who do electrical work, not general contractors generally. All right?
I got you. So you got to go through proper channels first.
Right. So that's your notification process, right, for grievances. And let's see, you got union rights, job accident report, label, termination slips, notice of vacancy, lending out, dues, check off, traveling employee, okay. Referral procedure, that's, again, if folks are violating any of this stuff, it's a chargeable offense, remember that. So if you've been blackballed before, that's a chargeable offense if you can prove it. If you're getting spun and you can prove that it's a personal thing, so that's a chargeable offense.
So what's the spun?
There's this nasty thing that happens, right? So a contractor will put in a call to the local and say they need 20 electricians, right? And let's say a number of electricians showed up, but it's not enough to fill the 20. But then they send back 5 because they don't want those 5 on that job. Now, there's certain folks who gain a reputation and their name gets circulated around, right? Mm-hmm. Well, if those folks go onto a job site, it's easy for a contractor to go, oh, this name's problematic. And then they send them back to the hall without giving them a fair shake. They may never have had this guy work for them before in their life.
They just know the name.
But they have something that's called right of first refusal, which is just horrible. Like, dude, you can refuse me without knowing me? When do we ever judge books by their covers, right? But that's in here. I hate that rule, but it's in here.
Can you use that for grievance too, or no?
No, because it's part of the contract.
Oh, gotcha.
So no, you cannot. It's in here that they're allowed to do that. So you can't. You have to have some concrete evidence to say they did it as a personal thing.
Like a vendetta, whatever you call it.
Right. They have every right to say, we don't want to hire you. Huh. It's foul, dude. I don't like it.
It's kind of screwed up.
Yeah, I don't like it. It's one of those things that I really hate. Like I don't know, man. Give somebody a fair shake, and if they screw up, fire them. There's no reason to just send them back because you don't like the way they look. You got job site conditions. Let's see what they have for job site conditions, because that would be a grievance, right? If the job site conditions are violated, right? Because you're between contractor and employee. So you got to understand, grievances are going to be between contractor and employee. Charges are going to be against other members. And remember that sometimes your foreman is just being a douchebag, and that's why he needs charges filed against him so that he stops being a douchebag. But it's not necessarily the contractor, because sometimes foremen who are shop rockets love to go all out to try to do as best as they can while screwing the membership just to make themselves look better. But we do have a remedy for that, and it's called the Constitution, the agreement, charges and grievances, baby. All right, so now we talked about job site conditions. Here we go. Section 4.19. The employer shall ensure that on all job sites, safe, cool drinking water is provided at all times. So if they ain't got safe, cool drinking water, that's a chargeable offense. I mean, a grievance. That is a grievance. And that supplies to clean and wipe hands in a sanitary manner are provided. I'm kind of disgusted that as a job site condition, it doesn't say clean restrooms should be provided. That's kind of irritating. But it talks about your contract covers everything. It covers disbursement of overtime. It covers your basic wage rates, your overtime shift. It covers all that stuff, right? And then you got your procedures for policing your union. Okay? You got working. Wait a minute. What was I just looking at? You got your working conditions, where it's telling you in section 4, it tells you a whole bunch of different things. Besides job site conditions, you got employee procedure, quality of work, faulty workmanship, foreman authority, superintendent's age ratio, personal vehicles, transfer time, overtime distribution, safety measures. They ask you to work in an safe fashion, that's a grievance. Machinery, fabrication and assembly, coverage and agreement, employee storage, hours, cable supply, all this stuff is covered. And if they violate the agreement, that's a grievance. If it's a member doing it to you, those are charges that you can file. And you should file, because we should keep each other accountable. That way, we make our union as strong as it can be, and really give people that are applying, give them a place to come work where we live out our values. And in many cases, it's not in all cases, because there are so many fantastic, amazing brothers and sisters that I've come into contact with over the years in my career. But there are also quite a few that just don't understand what being in a union is supposed to be about and how we're supposed to have each other's backs. And when you are bringing extra tools that are outside of the tool list, you're hurting the guy who is following the agreement, because you're not following the agreement, and it's a chargeable offense. And I hope that with education and information, we start to hold each other to a higher account, because we have to do better. It should be a far stronger union, a far more unified union, and the way you do that is if we all work and agree to comport ourselves to the same standards. Yeah. What do you think? You got any questions regarding what we just spoke about?
So expect more from you then.
Always expect more from me. If I'm ever failing, please tell me I'm failing. I don't mind. I don't mind learning. But do you have any questions? Anything you want me to cover before we end this?
No, I think you did pretty good. I mean, like I said, I didn't know about, like you said, I asked you a minute ago about earlier, whatever it was. But if I was having issues with another company, you had to go through your employer first. You don't have to fix.
Yeah, you can't just go to the union or to the IBW for a GC issue, because
or just, I'm saying
it's an issue between your contractor and them.
Yeah.
And if your contractor doesn't handle it, now you have an issue.
Or even with another company, like say like the plumbers or
whatever it is. If your company has your back and does the right thing, you're good. But if you raise the concern and they ignore you, well, now it becomes their problem, and now you have a grievance to file against your contractor because they ignored what you were trying to raise as a safety concern. I hope you found this video informative. I'm sorry, this was literally just live, and we just went over it now because we were talking about it, and it was something that I thought was important for our members who never read their contract in their life and don't know the process. At least now you can look at this video, maybe pique your interest, maybe open your contract and read it. I don't know. Maybe. Anyway, you guys got to keep in mind the fight is not left and right. It's up and down, and it's going to take solidarity to win. Always. I promise you that. Peace.